there any way I can get you your name?
No, but you can back up.
Well, how am I supposed to get your name if I can't read your name?
My name's not that important to you.
Yes,
right
sir,
now.
it
I'm
is.
Okay, and you're approaching me, and I'm asking
But
you to
you're
step
on
back.
duty. You're a public servant. I'm not.
I'm asking if you want to stand right here next to me. I can pat you down
I'm
for
just trying to
weapons
get
if you
your
want.
name. I'm just trying to get your name.
My door, I'm going to pat you down for weapons.
No, sir, you're not.
Yep.
No.
Well, then you can step away from my car.
I'm trying. You're stepping up on me, sir.
Well, I need to make sure you don't have any weapons on you is what I'm fixing to do.
What's up, you guys? Welcome back to Southern Draw Law. My name is James White, criminal defense attorney, former prosecutor, former police officer. Okay, so if you're watching this video, it's probably either because you got a recommendation for it and you're interested in Terry versus Ohio, or you watched part 1 of this series and you're here for part 2. If you haven't seen part 1, I encourage you to pause this video, click on the link to my channel, and go find the part 1 video. It's the video that I released right before this one. Watch it first so you'll have a frame of reference for where this picks up, and then come back and watch this one so you get the full picture. As promised, part 2 of this series is going to focus on the Terry frisk. So to recap, under the landmark case of Terry versus Ohio, the court laid out the framework for what a police officer needed in order to be constitutionally sound when detaining a person for investigation. We now call it reasonable articulable suspicion for short, but the actual language in the opinion said that there were basically 2 parts to consider. First was the Terry stop, and that had to be based on the police officer's ability to point to specific and articulable facts, which, taken together with rational inferences from those facts, would lead a person of reasonable caution to believe that criminal activity was afoot. In other words, without giving weight to his inchoate or unparticularized suspicions or hunches, but instead to the specific reasonable inferences which he is entitled to draw from the facts in light of his experience. An officer must be able to articulate facts that would cause a reasonable officer to believe that the person was committing, had committed, or was about to commit a crime. And if those facts are present, then the officer can briefly detain an individual for investigation and questioning. Now, the question then becomes, well, what about the Terry frisk? Because again, Terry was more than the stop. The actual end result of the holding was about the frisk. And I say that to further my theory that this really had a lot more to do with the undercover implementation of the doctrine of officer safety than anything to do with the actual Terry stop portion. But to give us an example of what we're talking about here, we're going to go look at a video brought to us by a channel called Handicap News. Now, I believe the owner of Handicap News is a journalist that works in the state of Alabama, and they're sort of an auditor or an independent journalist, cop watcher. And the video begins as the journalist is in a place called Southside, Alabama. He encounters a couple police officers patrolling a public park. The journalist approaches an officer as the officer appears to be running the license plate on a vehicle that's believed to be the journalist's vehicle and parked in the parking lot. The journalist tries to ascertain the officer's name and badge number. Now, I've made edits to the video in order to use it to demonstrate its relationship to a Terry frisk, but you should head over to Handicap News' channel, watch the video in its entirety, and give them credit for sharing it. And with that, let's watch what happens and see if this officer gets it right.
Pretty good. How about you?
Testing out your camera.
Yes, sir. Okay, I appreciate it.
You been fishing?
I don't answer any questions.
Okay. Well, have a good one, bud.
You too. Now, y'all be careful.
All right.
Facebook Live.
I don't answer any questions.
All right, man. Have a good night.
You too. Y'all be careful. You already got it, didn't you? Did you already get it?
Yeah.
Well, it's not going to come back as me, so. Can I have your name and badge number?
I don't answer any questions.
Okay. Well, I can put a complaint on you for that.
Okay.
Is there any way I can get you your name?
No, but you can back up.
Well, how am I supposed to get your name if I can't read your name?
My name's not that important to you.
Yes,
right
sir,
now.
it
I'm at a
is.
public park.
I am too.
Okay, and you're approaching me, and I'm asking
But
you to
you're
step
on
back.
duty. You're a public servant. I'm not.
I'm asking you to step back.
You're asking me.
Yeah.
Yeah. You're asking.
Well,
is
now
the
I'm
question.
telling you to step back.
Oh, is that an
because-
order?
Yes, it is.
It's an order.
Yes.
For what crime?
If you want to stand right here next to me, I can pat you
I'm
down
just
for
trying to
weapons if
get
you
your
want.
name. I'm just trying to get your name.
you're gonna stand right outside my door, I'm gonna pat you down for weapons.
No, sir, you're not.
Yep.
No.
Well, then you can step away from my car.
I'm trying. You're stepping up on me, sir.
Well, I need to make sure you don't have any weapons on you is what I'm fixing to do. You're not going to approach a police car
I'm just trying to get your name.
and try to harass me.
Let me
You can
get
read.
your-
You can
I'm
read it
not
right there.
harassing
It's
you.
right there. It's an officer safety issue. If you're going to sit there and walk right up to my car, I'm going to set you too nice on your car or inside your car right here.
Hope you know you just set yourself up for a lawsuit.
No, I absolutely did
Yes,
not.
you have.
You're not going to walk up to my
you
car.
just
and stand right
searched
outside my
me
car.
for no reason.
I did not search you. I
You're
patted
the
you down
one
for
that
weapons
wouldn't
and
give me
removed
your name. Hey, it's okay. I need some money. I need a payday from Southside.
Well, try all you want.
Oh, I will.
Found
I
out
just
the door,
did, didn't I?
Asking a bunch of questions.
And I just
without-
did, and you violated my f***ing rights.
No.
Yes, sir,
Try
you
again.
did.
Try again.
Oh, you know, I've already. You try again. You're the one that violated my rights.
I'm sitting at a
This is
public
how
park.
Southside rolls,
that.
and everybody's going to see it.
Okay.
You violate people's rights. You had no right to go in my pockets whatsoever.
When I pull a knife, is there another way that you're going to say I violated your rights?
No, the camera don't lie.
Okay. I mean, the camera's going to show me get out of my car and pat you down for weapons if you had it pointed.
Yeah,
at me.
you had no probable cause.
I don't have to have probable cause.
Yes, you do. In the state of Alabama, you have to have probable cause. No,
Okay.
I don't want to hear cock-splaining.
No, it's not cops explaining.
Yes,
It's
it
actually
is.
Alabama state law and the
No, it's
constitutional law
not.
of the state of Alabama.
No, it's
I
not.
don't have probable cause to have to pat you down for weapons. I have to have probable cause to search you.
You just
And when I
searched me.
when I
You
patted-
just
No.
searched me.
No.
Yeah, you did.
So we got a sergeant named Burridge or Barrage, I'm not sure how to pronounce it, but from the Southside Alabama Police Department. So this is a sergeant, they're a supervisor, they should know this stuff, but here we are. What do you guys think? So we know from the opinion in Terry that in order to do a justifiable frisk, we first have to have a constitutional stop. But more than that, in addition to a constitutional stop, we need the officer to have a reason to believe that the person being detained is both armed and dangerous in order to justify a Terry frisk. And again, the court defined a Terry frisk in the actual holding of the opinion where it said that we merely hold today that where a police officer observes unusual conduct which leads him reasonably to conclude in light of his experience that criminal activity may be afoot, and that the persons with whom he is dealing may be armed and presently dangerous, where in the course of investigating this behavior he identifies himself as a policeman and makes reasonable inquiries, and where nothing in the initial stages of the encounter serves to dispel his reasonable fear for his own or others' safety, he is entitled for the protection of himself and others in the area to conduct a carefully limited search of the outer clothing of such persons in an attempt to discover weapons which might be used to assault him. So again, let's break that down into the elemental requirements, okay? So number one, you got reasonable articulable suspicion that criminal activity may be afoot. Number two, a reasonable belief that the person may be armed and presently dangerous. Number three, he must identify himself as a police officer. Number four, he's supposed to make reasonable inquiries. Number five, in the process of doing his reasonable inquiries and investigation, nothing in the initial stage dispels his reasonable fear for his own safety or others' safety. And number six, when all of these things are true, then the officer can conduct a pat-down limited to the outer clothing to discover weapons. As an aside, understand that just like with Detective McFadden, an officer doesn't have to see a gun or a bulge or anything like that. It can just be a reasonable or rational inference based on the same information used to justify the detention. So just like Detective McFadden articulated that he thought Terry and Chilton and Katz were planning a robbery, the rational inference is that if they were planning a robbery, they might have had guns. And if they had guns, the rational inference meant that they were a danger to him if he chose to interact with them. And that's how the court arrived at a reasonable belief that they were armed and dangerous. Again, armed and dangerous could just be armed and dangerous to him when he went to encounter them. Again, the officer need not explain that he saw someone waving a weapon around or saw a bulge or heard them make a threat. None of that is necessary. All he has to do is be able to string the inferences together to make it make sense. And the courts will almost always say,
if the literature being read to the child isn't entertaining to the parent, throw it away.
Children's literature can be meaningful and compelling to us. One of the reasons why we read these great stories.
almost always say that if the officer has reason to believe that the person is armed, then the dangerous part is anchored to being armed. There's always, those two are like two peas in a pod. If you're armed, then you're dangerous to the officer as far as the courts are concerned. Even if you're armed illegally, like in today's world where a lot of states have gone to like constitutional carry and open carry, that doesn't matter. It doesn't mean that you're committing a crime. They could be detaining you for something other than that. They could be detaining you because they think you're going to commit some crime completely unrelated to a weapon. But if they determine that you are armed in the process of encountering you, then you are armed and dangerous to them, at least for the purposes of the encounter. And so therefore, the officer can take reasonable measures to ensure their safety. So looking back at the video we just watched, do we think this sergeant was able to do that here? Let's break it down and see how he performed. Well, why does he tell our friend at Handicap News that he's patting him down? Because he's standing next to his cruiser and is trying to get his name and badge number. Well, that's no good as far as Terry's concerned. Is there any indication whatsoever that there's criminal activity? Well, no. We're in a public park, public photography. All we're doing is asking for the officer's name and badge number, ostensibly to file a complaint. Okay, what's next? Is there anything happening that would give this sergeant any reason to think that Handicap News is armed and dangerous? Well, I would say no. What information do we have that would suggest that? Nothing. What's next? Did he identify himself as a policeman? Well, he's in a marked police car and the journalist approached him, so we probably don't need to worry about that element. What's next? Did he make any reasonable inquiries? He didn't really make any inquiries. He demanded that he back up, and that might be reasonable, but does he do anything to dispel his reasonable fear during the encounter? I would argue that his fear is baseless and not reasonable, so no, he didn't dispel any sort of fear, whether it was reasonable or not reasonable. But he did do something that's interesting. He invokes the religion of officer safety. He says it's an officer safety issue for you to be standing close to me, so I'm going to pat you down for weapons. Now, one of these days, I'll do a video on this channel for channel members when I start memberships. But briefing this case in law school was a mind-blown light bulb moment for me as a human being. I was 35 years old. I was sitting in criminal procedure in my second year of law school, and I found myself, to say the least, mortified at how many times I violated people's rights on the street without knowing it. In my law enforcement career, I was generally able to talk my way out of everything. I was crisis intervention trained. I understood mental health. I was the type of person who always kept like a burner cell phone and a pack of cigarettes. So if somebody was going to jail and they wanted to call their mama, they could use the phone, they could smoke a cigarette, they could calm their nerves, whatever. I always tried to treat people pretty well. I just didn't, I had less than 10 uses of force in a 10-year law enforcement career. I just didn't have a lot of the problems that you see on YouTube. So I wasn't violating people's rights because I didn't care, and I wasn't treating people poorly. I was just never trained to properly understand or implement Terry. I was trained to believe that officer safety was the only God I could serve. That's why I don't believe that all cops that we see violating people's rights are necessarily evil tyrants who just do it because they want to. I know that's not true because I know that wasn't true for me. So when I see people in the comments suggest that, all cops are the devil and that they're completely irredeemable and all that stuff, and then sometimes they'll say it to me because I used to be a cop, and it's like, guys, sometimes you just don't know. And I agree that I should have been held responsible if I had been sued and all that, and I agree that these guys should be held responsible. I'm just saying that there's not always like this malicious, malignant heart attached to people making mistakes. Everybody who's watching this video has made a mistake, probably a major mistake, for which they could have been fired, sued, arrested, whatever at some point in their life. That doesn't mean that they're an irredeemable person, or that they're terrible and they deserve to have terrible things happen to them. Sometimes you just make a mistake because you don't know any better, regardless of whether you should know better or not. That's just not the way it always works. I mean, I didn't escalate stuff just for fun. I never believed there was like an us versus them, where it was like the police versus the public. And I just didn't have an ego-driven or malicious heart. I just thought that anyone I got out with, I could pat them down for officer safety. If I got out of the car and interacted with somebody like in a field interrogation capacity, I asked everybody I got out with to put their hands on the front of my cruiser, and I patted them down for officer safety. I was nice, I was courteous, and I still violated their rights. I know that now because I know that Terry versus Ohio is a one-way street. On one end of the street is a Terry stop, and on the other end of the street is a Terry frisk. You can have a Terry stop on the left side of the street here and never have justification to proceed to a Terry frisk because you don't have armed and dangerous or whatever. But you cannot ever get to a constitutional Terry frisk on the right side of the screen here where you did not start with a lawful Terry stop. Now, you can get in someone's pockets when you have consent or probable cause based on something else, or to do a search incident to a lawful arrest or whatever. But in the realm of Terry versus Ohio, if you pat someone down for weapons and you don't have consent and you didn't start with a constitutionally sound Terry stop, then you're messing up and you're violating the Fourth Amendment, in my opinion. Now, let's take a look at some of the language the court used in Terry that should have signaled that officer safety was going to be a huge problem. Well, for one, they kept saying that the police had a right, and the holding said that the officer was entitled. That's not a minor detail. At one point in the opinion, the court reasoned that the sole justification of the search in the present situation is the protection of the police officer and others nearby, and it must therefore be confined in scope to an intrusion reasonably designed to discover guns, knives, clubs, or other hidden instruments for the assault of the police officer. They went further to say that we are now concerned with more than the governmental interest in investigating crime. In addition, there is the more immediate interest of the police officer in taking steps to assure himself that the person with whom he is dealing is not armed with a weapon that could unexpectedly and fatally be used against him. Certainly, it would be unreasonable to require that police officers take unnecessary risks in the performance of their duties. American criminals have a long tradition of armed violence, and every year in this country, many law enforcement officers are killed in the line of duty. This is the court. The official language of the court's opinion is what I'm reading here. Every year in this country, many law enforcement officers are killed in the line of duty, and thousands more are wounded. Virtually all of those deaths and a substantial portion of the injuries are inflicted with guns and knives. In view of these facts, we cannot blind ourselves to the need for law enforcement officers to protect themselves and other prospective victims of violence in situations where they may lack probable cause for an arrest. When an officer is justified in believing that the individual whose suspicious behavior he is investigating at close range is armed and presently dangerous to the officer or to others, it would appear to be clearly unreasonable to deny the officer the power to take necessary measures to determine whether the person is in fact carrying a weapon and to neutralize the threat of physical harm. This is actual language from the opinion. So this should have told us all along that officer safety was going to become the law of the land. You see, most people think that the first time the Supreme Court created a constitutional right out of thin air was in Roe versus Wade in 1973, but that's not the case. 5 years before Roe, in 1968, we just read the language of the opinion where the Supreme Court of the United States created a police officer's right to safety and wedged it right into the cracks that the court created in the Fourth Amendment, thereby creating basically a police officer's constitutional right to officer safety. And without realizing it, this court did the exact thing they said they weren't doing. The court actually said, in part of its opinion, we turn our attention to the quite narrow question posed by the facts before us. And this was the only question that the court purported to answer in its opinion: whether it is always unreasonable for a policeman to seize a person and subject him to a limited search for weapons unless there is probable cause for an arrest. So the point of the holding in Terry was supposed to be to address a single narrow question: is it always unreasonable to stop and frisk someone without probable cause for an arrest? But the opposite happened, due to the fact that the court, in an almost double-speak type maneuver, created a brand new right to officer safety in its holding. It began by considering the government's interest in the safety of officers charged with the duty of proactively combating crime. And then it coupled the officer safety interest with society's interest in combating crime altogether. And then it balanced those interests against the liberty interests of the people who might be stopped along the way. And if you haven't been keeping score, that's 2 on 1. 2 governmental interests to 1 liberty interest. So you got officer safety plus public safety against individual liberty. And what they came up with is that the interest of the government in keeping cops safe as they investigate crime is substantial enough that it warrants reducing our personal liberty in cases where the officer has reasonable, articulable suspicion that criminal activity is afoot. It sought to give the police rules for investigative detentions and frisks, but more importantly, it set the foundational blocks for a new foundation of officer safety that would parallel the liberties guaranteed to all of us by the Fourth Amendment for the next 56 years, and still to this day as we sit here making this video. The holdings that came in the next cases, Pennsylvania versus Mims was next, and it was upheld because the court determined that a traffic stop was basically an investigatory detention under Terry versus Ohio, and that once the driver was already lawfully stopped under Terry, getting the driver out of the car as a precaution for officer safety was a de minimis intrusion and authorized under the Fourth Amendment. The case that followed Mims, Maryland versus Wilson, took the holding in Mims and extended it to passengers on a traffic stop. And it traced its reasoning back to Mims and back to Terry, because it said, well, look, if a traffic stop is a Terry stop, and Mims said that to get the driver out is no big deal because they're already lawfully stopped, well, then why is it a big deal to get the passenger out? And it's this slippery slope in action that we're actually watching. It starts with Terry, then it goes to Mims, then it goes to Maryland versus Wilson. Every major case that examined what the police can and cannot do as it relates to interactions on the street is built on the back of Terry versus Ohio. All roads lead back to this case. In closing, all I want to do is read to you the lone dissent in the case of Terry versus Ohio because it was beautifully written by Justice Douglas. He says, I agree that petitioner was seized within the meaning of the Fourth Amendment. I also agree that frisking petitioner and his companions for guns was a search, but it is a mystery how that search and that seizure can be constitutional by Fourth Amendment standards unless there was probable cause to believe that 1, a crime had been committed, or 2, a crime was in the process of being committed, or 3, a crime was about to be committed. The opinion of the court disclaims the existence of probable cause. If loitering were an issue, and that was the offense charge, there would be probable cause shown. But the crime here is carrying concealed weapons, and there is no basis for concluding that the officer had probable cause for believing that that crime was being committed. Had a warrant been sought, a magistrate would therefore have been unauthorized to issue one, for he can act only if there is a showing of probable cause. We hold today that the police have a greater authority to make a seizure and conduct a search than a judge has to authorize such action, when we have said precisely the opposite over and over again. In other words, police officers up to today have been permitted to effect arrests or searches without warrants only when the facts within their personal knowledge would satisfy the constitutional standard of probable cause. At the time of their seizure without a warrant, they must possess facts concerning the person arrested that would have satisfied a magistrate that probable cause was indeed present. The term probable cause rings a bell of certainty that is not sounded by phrases such as reasonable suspicion. Moreover, the meaning of probable cause is deeply embedded in our constitutional history. As we stated in Henry versus United States, the requirement of probable cause has roots that are deep in our history. The general warrant, in which the name of the person to be arrested was left blank, and the writs of assistance against which James Otis inveighed, both perpetuated the oppressive practice of allowing the police to arrest and search on suspicion. Police control took the place of judicial control since no showing of probable cause before a magistrate was required. That philosophy, rebelling against those practices, later was reflected in the Fourth Amendment, and as the early American decisions both before and immediately after its adoption show, common rumor or report, suspicion, or even strong reason to suspect was not adequate to support a warrant for arrest, and that principle has survived to this day. It is important, we think, that this requirement of probable cause be strictly enforced, for the standard set by the Constitution protects both the officer and the citizen. If the officer acts with probable cause, he is protected, even though it turns out that the citizen is innocent. He's given us a precursor in this opinion to qualified immunity, by the way. Just pay attention. And while a search without a warrant is within limits permissible if incident to a lawful arrest, if an arrest without a warrant is to support an incidental search, it must be made with probable cause. Now pay attention to what he's saying here. This is 1968. This immunity of officers, he's referring back to what he said a few seconds ago. If the officer acts without probable cause and it turns out the citizen's innocent, he's protected. He's talking about the officer being immune from suit if he makes an arrest on probable cause, but he's wrong. So he's going back, and he says this immunity of officers cannot fairly be enlarged without jeopardizing the privacy or security of the citizen. So he's basically saying that by carving out a new place for officers to hang out, reasonable articulable suspicion, you're expanding their immunity to include reasonable articulable suspicion. And that can't be done without jeopardizing the privacy or security of the citizen. And my goodness, is that ever true today? Back to his quote, the infringement on personal liberty of any seizure of a person can only be reasonable under the Fourth Amendment if we require the police to possess probable cause before they seize him. Only that line draws a meaningful distinction between an officer's mere inkling and the presence of facts within the officer's personal knowledge which would convince a reasonable man that the person seized has committed, is committing, or is about to commit a particular crime. In dealing with probable cause, as the very name implies, we deal with probabilities. These are not technical, they are the factual and practical considerations of everyday life on which reasonable and prudent men, not legal technicians, act. This section is so powerful. To give the police greater power than a magistrate is to take a long step down the totalitarian path. Perhaps such a step is desirable to cope with modern forms of lawlessness, but if it is taken, it should be the deliberate choice of the people through a constitutional amendment. Until the Fourth Amendment, which is closely allied with the Fifth, is rewritten, the person and the effects of the individual are beyond the reach of all government agencies until there are reasonable grounds to believe, probable cause, that a criminal venture has been launched or is about to be launched. There have been powerful hydraulic pressures throughout our history that bear heavily on the court to water down constitutional guarantees and give the police the upper hand. That hydraulic pressure has probably never been greater than it is today. Yet if the individual is no longer to be sovereign, if the police can pick him up whenever they do not like the cut of his jib, if they can seize and search him in their discretion, we enter a new regime. The decision to enter it should be made only after a full debate by the people of this country. That's all for this one, guys. Thanks for tuning in to part 1 and part 2. Please remember to like and subscribe. I'm going to be doing more videos in series like this. I'm going to do one on Pennsylvania versus Mims. I'm going to do one on Maryland versus Wilson, Rodriguez, which is one of my favorite cases. Leave me a comment on this video, guys, and let me know what you think. Please check out some of the other videos on the channel and leave a comment on there as well. Until I see you again.